All right, well, we might get started. Welcome everyone to today's webinar. I'm Karsten Duvel, the new Policy and Communications Officer at SCAQ. I'll begin today by acknowledging the traditional custodians of the Yagara country on which we are hosting this webinar from today and pay my respects to their elders past, present and emerging. I extend that respect to Aboriginal and Torres Strait Islander peoples joining us today. It's an exciting time to be in Strata with the Body Corporate and Community Management and Other Amendment Bill 2023 passing Queensland Parliament recently. The change brings new challenges and opportunities in areas like pets, parking, smoking, and scheme termination. It's important to know that these changes only come into effect following proclamation, of which there has been no date set yet, but SCAQ will keep everyone up to date when the new laws commence. We're joined today by two very respected professionals in Strata, Jessica Cannon and Duncan Lee. Jessica is a highly regarded Strata lawyer, the chair of the SCAQ Legislation Committee and the SCAQ Lead Advocacy Director. Duncan is a senior body corporate manager and the owner of Pinnacle Strata, our board's senior vice president, and has served on the SCAQ Legislation Committee. I'd like to thank Jessica and Duncan both for kindly offering their time this evening to talk us through the Strata reforms in Queensland. I would also like to thank our education sponsors for their ongoing support of SCAQ, Macquarie Bank, Altogether, Strata Max, Grace Lawyers, Strata Community Insurance, BCB, Hum Energy, Express Glass, and Build Check. Before we get underway, just some quick housekeeping. For CPD purposes, if you are screen sharing, please let us know in the chat or alternatively email education.qld@strata.community within the next 7 days to advise. If you do not advise within the next 7 days, we will be unable to award the CPD points. If you have registered for the webinar, your CPD points will be automatically allocated. All right, and I'll pass on to Jess and Duncan.
Thanks, Karsten. I really appreciate it. And good afternoon, everybody, to round two of the bill, which has now very importantly passed on the 15th of November after a lot of debate for those that did decide to dial in and listen to the debating with various different members and the like. Now, Duncan and I were quite literally still debating the practicalities of this bill before we dialed in, and have done so over the weekend as well. So we have prepared some slides today. We've also prepared a flow chart with respect to scheme termination, but we do temper a lot of this with, especially when it comes to the scheme termination, it's going to be a bit of a work in progress, and seeing the practicalities of how this new regime might roll out in terms of the people on the ground, the schemes that are looking to terminate, and the different complexities that this bill is ultimately going to face. As Karsten did say, there is no current set commencement date. So that is still open to being set. We will keep you up to speed as much as possible. And the other important point to note is our presentation today is very much focused on the amendments to the Body Corporate and Community Management Act. There are some other pieces of legislation that this bill touches on, which we just simply won't have the time to get into today. So, and those other pieces of legislation, I believe some of them have some commencement dates set. So please note that for yourselves. Bit of a run sheet for today. We're going to focus on 6 main points. And we're going to hit it off with the most topical, which is scheme termination. We'll move into smoking, pets, towing, bylaw enforcement and layered arrangements, and actually another amendment to layered arrangements, and then also talking about alternative insurance. I would prefer, and Duncan, happy to hear your thoughts on here, but if we could hold off questions to the end, that would be great. But yeah, obviously we will try and get back to any questions that pop up as best as we can, and hopefully we answer them already with the material that we've prepared.
Very good.
Right. Did you want me to take this one, Duncan?
Oh, no, look, I'll take over. That's fine. That's okay. Okay, so there's now a number of processes that are available for scheme termination. There's the existing processes that we know of by resolution without dissent and also a court order. And now there's the application of the economic reasons for termination. And I think it would, I don't think it's unfair to say that this is complex, a little bit convoluted, and difficult to understand the process that needs to be adopted. And as Jess said earlier, we've spent quite a bit of the weekend and today, even up until 3:59 today, of going over some of the nuances that are included in these scheme terminations. So what I'll do is I'll give a very broad overview, and then just can run through the finer details with a flow chart that she's prepared that goes through all of the steps. So if a body corporate was looking at terminating under these particular provisions under the Body Corporate and Community Management Act, it needs to go through a process of having a pre-termination report prepared and providing that pre-termination report to all of the owners at least 90 days before any decision can be made on that. It needs to be a general meeting decision, and it needs to be a majority resolution. Once the body corporate has passed what's called an economic reasons resolution, it can then also pass a termination plan resolution. And to the best of our knowledge, those two resolutions can be decided at the same meeting, but the economic reasons resolution needs to occur first. It needs to be passed by a majority resolution and then move on to a termination plan resolution. Then there's a whole slew of requirements the body corporate must meet in terms of notification periods before it goes on to preparing a termination plan, giving that termination plan to all owners at least 120 days prior to the body corporate considering that termination plan. Then at a general meeting, a termination resolution can be passed with at least 75% of owners voting in favour of that resolution. That's very much the broad brush overview of the approval process in its simplest form. But then we need to get into the nitty-gritty detail of what happens along the way. So Jess and Karsten, have we got that flow chart that can be put up on screen just to give an overview of what we're looking at for that process?
I'll just grab that one up. Is that showing?
That
Yep.
is perfect.
Yep, perfect.
All right,
And
so everybody.
I was just going to suggest maybe we can go from top to bottom and show all of the permutations before we go through them all at a time, each at a time, because it is rather complicated. It spans over 2 pages of different paths that can be followed to get to that termination. So can we just scroll down there if that's possible? And over the page. So that's I guess, a visual overview of the complicated process that would need to be followed. When we go back up to the top, just can go through some of these line by line.
All right, so we sort of promised this in our last webinar where we spoke about the bill and we said if the bill is passed, then ultimately we'll turn our minds to a flow chart. That was my Saturday, and I think Duncan's either Saturday or Sundays. It was turning our minds to this flow chart. Now I will temper this by saying this is version 1. And I think this is going to be a working document that we're going to keep building on and improving, especially when it comes down to the practicalities of how this new process can actually be rolled out in practice. I also want to say where we are quoting sections of the bill, they're not a cut and copy. So this is just what we think are the important elements, especially when we're dealing with the pre-termination plan and the termination plan that you'll see in a minute. By all means, when it actually comes to doing these types of plans, or if you just had a particular interest in it, please jump into the bill and look at Section 81 capital C to get the full information that these plans would need, because these are very much just what we think are the crucial elements. So first step, as we know, is the pre-termination plan. What is that? It is very much designed to be an overview of what owners are to expect if termination is ultimately rolled out within their particular scheme. So things like market valuations for the lots, market valuations for the scheme land. It looks at body corporate assets, the value of the assets, but also nature and extent of any liabilities held by the body corporate. And it really looks at giving almost like a statement of assets and liabilities for the body corporate. I'm sure most of you would have seen those either in your individual capacity or companies or businesses that you've been involved in before. Normally certified accountants produce them, and it gives you a rundown of, okay, assets are worth this amount, liabilities are worth that amount. Broadly, what are we looking at in terms of how to value this particular scheme? It needs to be prepared by an appropriately qualified person, and there's different elements here, which is really interesting in terms of what goes into this pre-termination plan. They all come down to the economic reasons test. We've included the economic reasons test there for you. And there's two different ones. The first test is really for commercial schemes and lots that are purely commercial in nature. And it's quite a straightforward test. And that's that it's no longer economically viable for the scheme to continue. Pretty straightforward. Now, if you apply that to the pre-termination report, then you only need an appropriately qualified person to be able to prepare this report for you. But if you have a mixture of commercial and residential or purely residential, then you fall into the second tier of the economic reasons test. And that's that on the day of the pre-termination report, or within 5 years from that day, it's not, or it will not be economically viable for the scheme to carry out repairs and maintenance to the property or assets the body corporate must maintain in a good or structurally sound condition. So a much broader test that's going to apply for residential-based schemes. Importantly, when it comes to then preparing your pre-termination report, you've got a couple of other hurdles or individuals and entities that you need to bring into this. So you need to have a structural engineer pass an opinion on the actual structural integrity of the property and the assets. You still need the appropriately qualified person to work with the structural engineer, and also a quantity surveyor coming in to estimate costs identified in the report as well. So instead of just having one individual come in and do that work, you're probably going to have about 3 individuals coming in to do that work. Now, a point that Duncan and I were debating earlier is, why the difference? Why do we have quite a simplistic view on commercial lots and commercial schemes, but then we have a more complicated test and process when it comes to schemes that have some element of residential use in it? And what we put it down to is probably akin to the different modules that we have. You have a commercial module and then you have your standard module. Your commercial module is very much designed to be a little bit more lax in terms of the formalities. And often that comes down to the drafters turning their minds to their commercial lots in use. That means that they've got a business nature to them rather than somebody's home. And ultimately, that's what you're dealing with when you are dealing with residential schemes. You're dealing with people's homes. So we put it down to, rightly or wrongly, the same methodology or the same reasoning that you have behind different regulation modules. And that's that when you have that residential component, you need a greater level of scrutiny, a greater level of process and steps involved when looking into something as significant as a termination of that particular scheme as well.
And Jess, I think you said it quite succinctly when we were discussing it earlier that there's less emotion attached to commercial properties.
Yeah, far less emotion attached to it. Now, the pre-termination plan has to be given to all owners within that scheme at least 90 days prior to the general meeting. Now, this is your first general meeting in this process. It can consider 1 or 2 motions, according to Duncan and my many debates on this. Your first motion that it's going to consider is your economic reasons resolution. So that is owners, here's a pre-termination report. We've had either 3 people involved in it or 1 person involved in it, and they've come to a conclusion that there's economic reasons or not. Now, presumably it's a yes, there are for you to see a motion presented at a general meeting. But this is the first opportunity for owners within that particular CTS or scheme to say whether they believe that there are economic reasons to ultimately trigger further steps in the termination process. Now, importantly, your motion must state economic reasons and highlight those economic reasons back to the pre-termination report. So it's got to give some guidance, some information, some education to the owners about what it is that these qualified individuals or entities have developed for that particular scheme. It's also got to be passed by a majority resolution as well. Might just scroll down a little bit there if you don't mind, Karsten.
Just while Karsten's scrolling down, I think it's also worth mentioning in terms of those economic reasons, simply stating that the land value is worth greater than the market value of the lots in the scheme combined isn't considered an economic reason under these amendments, because the economic reasons relate to the maintenance of the buildings, not any value of the land. If owners believe that the land value is greater than the aggregate value of all of the lots included in the scheme, they do have avenues via resolution without dissent or making an application under Section 70 for a court order for termination, but it doesn't fall within the scope of these particular regulations.
That's a really good point, Duncan. Now, the second motion that first general meeting can consider is your termination plan resolution. And that actually presents at point 3 here. But before I get into that, I will just quickly outline the first dispute avenue. And again, Duncan and I had a good chuckle about this over the weekend, that my flowchart focused on all the dispute resolution avenues and Duncan's focused very much on the practicalities of how this is going to roll out. Yep. But importantly, it was a big topic that the public hearing focused on, and also the various debates focused on, is what avenues are there available for owners that are presumably in the minority to ultimately challenge this process. And there's 2 of them that presents in this bill. The first one is via specialist adjudication. So if a resolution is passed, and that's an economic reasons resolution is passed, or a termination plan resolution, which I'll get to in a minute, is passed, then an owner of a scheme can seek specialist adjudication on the grounds that the resolution should not have passed. So this is really interesting part of this bill. There are not only different avenues available at different points in the process, but there is recognition on who can actually bring a dispute, and also on what grounds or what orders they can seek in that process. And it is different to which entity or individual is bringing the actual dispute as well. So the first one is, if the resolution is passed, more often than not, you'd have a disgruntled owner. So hang on a minute, no, I challenge this resolution. I don't agree that there's economic reasons, or I take some type of issue with the termination plan, I want to ultimately lodge a dispute with the specialist adjudicator. Now, the second avenue in this is if the resolution does not pass. Now, this isn't just confined to an aggrieved owner. A body corporate can actually bring this application as well. So the body corporate or an owner can seek a specialist adjudication on the grounds that the resolution should have passed. So this again is where you've got to check your bill to make sure what avenues of recourse and what orders you are ultimately seeking out of the specialist adjudication. To further complicate the process, you then have to have an application lodged within your objection period. They're both the same period, but starting on different dates. So for a resolution that has passed and for an owner that ultimately wants to seek to challenge that resolution and say it shouldn't have passed, they have 90 days from when the owner received notice of passage of the termination plan resolution. And again, I'll come back to when that happens in just a minute. For the body corporate or for an owner that wants to see a resolution enacted, but it was ultimately voted down at a general meeting, they again still have 90 days. But they have 90 days from, on my reading, the date of the general meeting, or AKA the date in which the economic reasons resolution was considered by the body corporate. And these can be different dates, everybody. So I'll get to the passage timing in a minute, but they can very much be different dates, hence why it's really important for this flow chart to come through. If either application is made, then the practical effect is that the body corporate isn't able to proceed with any further steps in the termination process until such time as the specialist adjudication is ultimately resolved as well. All right. So the termination plan. Now, this can be the second motion in your first general meeting. And what Duncan and I have debated a lot about is what's the purpose of this resolution? If it is the case that owners are ultimately saying, yep, we've got to terminate a pre-termination report. Yes, we're satisfied that there are economic reasons that exist. What's next? Well, according to the bill, the body corporate then needs to prepare a termination plan, which goes into much more detail about the termination, the who, the what, the when, the how, and the like. Now,
I'll just jump in there just very quickly, because the discussion was really on the purpose of the termination plan resolution, because a termination plan resolution needs to be passed before a termination plan can be prepared, and the discussion was on whether if a body corporate passes an economic reasons resolution, it seems to follow that by necessity it would also pass a termination plan resolution by majority resolution. So if those two things follow, why ask the question twice?
Yeah, no, that's a good point to distinguish there, Duncan. And it's ultimately what we've come up with is the termination plan resolution is the body corporate resolving to proceed to commission a termination plan. And that's probably going to be a costly process. So there'll be a level of expenditure that would be required in there, but ultimately a signal from the owners to the body corporate committee to say, yeah, we want to take another step in this termination process as well. Would you agree with that, Duncan?
Absolutely, yes.
Yeah. So importantly, what you need to consider then is if it's all resolved, what needs to be included in this termination plan. And like I said, it's a follow-on in my view from the pre-termination plan, but you're really looking at the greater detail that's involved. So again, this is only a snippet of what we view to be the key elements of this section 81 capital B, there are more elements in the bill as well. But looking at the minute detail, so if you're selling to one entity, who is that entity? Is there a proposed settlement date that's involved? When do you need to give vacant possession by? You know, costs and expenses to be deducted from the sale price. How it's being proposed to distribute any type of value or monetary amount received for assets by the body corporate to the owners. How are the liabilities going to be dealt with as well? It also deals with the lessee component, which is really important. So if you have leases on your lots, what's the proposal to deal with those lessees in terms of their lease arrangements? If you have a caretaking entity or a letting agent, what's the proposal to deal with their type of contractual arrangements that are in place as well? So it's a deep dive. It's if we proceed with that, because that is the next step to ultimately resolve, to proceed with termination, what is this and how is this all going to play out at a practical level? And it's not just focused on owners and the sale prices for owners. It's very much focused on other entities and other individuals that are involved in the scheme that will have some type of flow-on effect from the termination or the dissolution of this particular scheme as well. Did you have anything else to add there, Duncan?
No, I think you've pretty much hit the nail on the head with the process there and the duty of disclosure for the body corporate, and that the process for approval.
Yeah. So with this one as well, once you do this termination plan, the body corporate must give each owner within the scheme a copy of the plan at least 120 days before the termination plan resolution is put up. So this is really important here with the time frames available, making sure that owners have sufficient time to get across the detail, obviously seek their own advice about the detail as well. And then you're heading to a second general meeting too. So we might just scroll down there, please, Karsten. All right, so your termination plan resolution, and this is where I think the actual flow chart here, we're going to have to do a bit of work on the practicalities of how this is all going to play out, because it's going to depend on the process of whether you do your economic reasons and your termination plan resolution in one general meeting or whether you do it in two general meetings. It'll also depend on your expenditure limits for your body corporate, I would assume as well, Duncan, because depending on how much these plans cost, they may not need a general meeting for the expenditure component. Committees may have the expenditure requirements in there. And that's an important point to note for the pre-termination report as well. You know, you might have to have a general meeting before that pre-termination to approve that expenditure.
Yeah, that's a good point, yeah.
But importantly, your pre-termination resolution, it's got to go to a general meeting again. It's another majority resolution. So your first two resolutions are majority. Your second resolution, your third resolution, which is your termination resolution, is your 75%. Now, if it is resolved, so if you do get your termination plan resolution resolved, a body corporate has 14 days after the passing of the resolution to distribute to the relevant person or a relevant person, which I'll explain in a minute, a copy of the resolution that was passed. So you remember before I spoke about your specialist adjudication and your objection period. This in the Act is called your notice of passage of your termination plan resolution. So it's the obligation that rests with the body corporate that if this resolution is passed, the body corporate then has to distribute written notice to relevant persons that the resolution has ultimately passed. The bill describes relevant persons, and this is another interesting point that Duncan spoke about in our first webinar, there's different parties that are involved throughout this process. We're not just focused on owners, we are focused on other third parties and interested parties within the scheme getting this information too. But a relevant person is an owner of a lot, a person who has a lease on a lot which is 6 months or more, a registered mortgagee, a caretaking service contractor, and a letting agent. So the body corporate has to, within 14 days, issue those categories of people, if they are relevant to the particular scheme, notice of the passage. Now, I would think, Duncan, this would just be in the form of minutes of the general meeting that would go out. But it doesn't expressly state that. It just says written notice is satisfactory.
Yeah, that's right. It's not specific. And then another interesting point of note is that of all the people who are relevant persons, it's still only the owners of lots included in the scheme who can object at that point. The other people, it's really just for their information.
Yep. No, that's a very good point. And this is, again, the importance of figuring out at what point do you bring ultimately a dispute. And still, even at the termination plan resolution stage, most of that dispute would fall under specialist adjudication still. So it's still looking at owner bringing it if it's passed and they don't want it to pass, or a body corporate or owner bringing it if the resolutions fail and they wanted them to pass. So a bit different there. Now, your fifth and final step in this whole process, if a scheme was ever to get there, is your termination resolution. So this is the one that ultimately is your 75%, your final rubber stamp to say, yes, we as a scheme and as owners want to proceed with our termination. It's a general meeting. Importantly, the bill actually turns its mind to saying that no other motions going to alternative ways to terminate a scheme can be presented in the same general meeting. So it's quite literally, we have followed these 4 steps in this process, and it's this way or the highway, essentially. 75% or more of owners have to vote in favour of it for the motion to be carried. No use of proxies, and an owner who owns a body corporate debt can still vote on this motion. So a couple of complexities there around the actual voting and formalities.
Yeah, it's also 1 vote per lot, no poll, nothing of that nature, just strictly 75% of the number of lots in the scheme.
Yep. Now, if your termination resolution is resolved and passed, the body corporate has a further 2 weeks after the motion is decided to give each of the relevant persons notice in the approved form, advising the entity whether the motion is passed. So that there actually makes me think that it's whether the motion is passed or not passed that they would get that notification, Duncan, which is a bit different to the termination plan resolution. And it's probably because it would trigger then an obligation to distribute the minutes broader than just the owners. So in the ordinary course, only owners would get the minutes. That would leave a fair chunk of those relevant persons unaware of the outcome.
That's right. Yeah. So it's in the termination plan resolution, there was an obligation to notify a number of parties if that resolution was carried, and then as purely for courtesy, if the termination resolution isn't carried, those same parties should be notified that it wasn't passed.
Yeah. Which makes sense, because it'd bring a finality to the matter, wouldn't it? And for the likes of mortgagees, caretaking service contractors that don't own lots within the scheme, unless they were to do a body corporate record search, they wouldn't become aware of the outcome of the actual voting in that process. Now, at this point, this is when the second dispute avenue is enlivened. And it's a court application that would ultimately be lodged. Who can apply? The body corporate subject to a termination plan, but only if the termination resolution was considered but not passed. So this again, excuse me, is where we have distinct orders or outcomes that certain entities or individuals can seek in these dispute resolution avenues as well. So for a body corporate, it's triggered where the termination resolution has been considered at a general meeting, but ultimately not passed. And then the body corporate would be seeking an order that the termination plan be implemented or be varied. So this is where we could look at orders to say, we like this termination plan, but based on feedback or further reporting done, we would like some level of variation to be adopted there as well. The second group of or category of people that can lodge a court application are ultimately owners. But owners can only lodge an application if the termination resolution was considered but not passed, and seeking an order that the termination plan be implemented, or if the termination resolution was passed, that the resolution should not have passed, or that the termination not be implemented, or that the termination plan be varied. So broader scope than what the body corporate has there. Body corporate has quite narrow outcomes that it can seek in an application. Owners have broader outcomes that it can seek. There is still scope when it comes to the court applications for other interested parties to the scheme to lodge applications. So a person appointed as a facilitator, a lessee, your service contractors in the sense of caretakers or letting agents. But importantly, their outcomes are quite limited in the sense that they can only vary or seek orders to vary the termination plan. So again, very important to turn your minds to who is bringing the application, who's the aggrieved person, what then are the outcomes that they can ultimately seek from that process. When to apply, so another deadline to keep in mind, applications must be filed 90 days after the day that the body corporate gives notice of termination, or another period that a court allows as well. So that then is 90 days after your 2 weeks. So body corporate has 2 weeks to notify relevant persons of the outcome. It's then 90 days after that a court application can be lodged. Anything to add there, Duncan? I think that's a fair overview of what we've wrapped our heads around so far.
But I think I'll go back to something that I wrote down very early in the piece when reviewing all of this, because I think everyone's probably had a lot of information to absorb and is maybe just getting a little bit glazed over. Is that one of the first sentences that I wrote down is unlikely that this will be completed in practice, more likely to be a catalyst for reaching a negotiated settlement / sale. And that's how similar legislation in other jurisdictions has actually been applied, that at the end of the day, very few schemes in other jurisdictions have been terminated through similar legislation. It's just brought the parties together to negotiate a settlement because they know that this is an option to the parties to force a sale if they have to.
No, look, I couldn't agree more. It's, other states have similar processes to this, and as I understand it, it is quite a difficult process. It's also an expensive process to follow through with. So as much as it is another third avenue to explore, it'll be very interesting to watch this space in terms of how it's rolled out in practice, but also how many schemes actually get to the stage of terminating. The other thing that we haven't commented on in this flow chart, purely because of the information that we've already got in there, is the bill pays very specific attention to conflicts of interest when these plans are being prepared. So it is something that, you know, the suitably qualified person, the quantity surveyor or the structural engineer has to complete conflicts of interest checks as well throughout this process. The viewer is obviously keeping it very much at arm's length and making sure that the entities and individuals involved in passing these opinions have no connection or interest in the scheme or anybody in connection with the scheme as well. So that was a big point that was really focused on in this bill. And it has come through into the final version and will come through into legislation as well. So it's important on that front to ensure that any reports that are ultimately going to be obtained in this process, those conflicts of interest are checked off too. All right, we might jump into, just mindful of the time, everybody, the other amendments, and then we'll get to questions at the end. Does that sound okay to you, Duncan?
Sounds good. And just, did you want me to run through some of these? Because you've been taxing your voice quite a bit as we go through. So my list is in a slightly different order to yours. So we're starting with smoking bylaws. Okay, so with the smoking bylaw, and just correct me if I'm wrong on this, I think a good place to start is the amendment to section 167 with the definition of nuisance, because nuisance has been added into smoking is specifically been added into a nuisance, so it doesn't just have to be a hazard as previously decided by adjudications. One question that I did have for Jess, though, is it does specifically say in subsection 2B that it is if smoking is if somebody is regularly exposed to the smoke or emissions from the smoke product. And my question is, what's regularly? Does that mean that it's smoking every day, smoking every week, or is it, say, if somebody's regularly smoking that one cigar that they like to smoke every birthday, would that be considered regularly for the purposes of this amendment?
Yeah, look, it's a really good question, isn't it? And it applies not only to the smoking, it really applies to any type of nuisance or noise complaint in a body corporate. It's the idea of there needs to be a level of give and take in strata living. And you know, as we've seen in a lot of case law historically, Duncan, it's that, you know, the abnormal sensitivities test as well. So regularly, in my view, will be a constant pattern or frequency which somebody can evidence is causing an unreasonable interference with their use and enjoyment of their lot or common property. Now, obviously, this is where you still get disputes. You know, is that level of frequency and abnormal sensitivity or not? Is there a satisfactory level of give and take that's available there? So I still think there's going to be an element of dispute when it comes down to the application of that revised 167. But the importance is that the nuisance provisions have been broadened. And that means that disgruntled occupiers actually don't just have to rely on the bylaws. They have a statutory protection under 167 that they can rely on, irrespective of what their bylaws say when it comes to smoking.
Yeah. And then if we're looking at the bylaws can be quite restrictive now when it comes to smoking if those bylaws are passed at a general meeting, and those restrictions can apply to common property. It can apply to areas that are allocated as exclusive use, or areas that are included in part of the lots as well. So again, just turning your mind to it, Jess, is there any areas that you would say would be unreasonable for a body corporate to have a bylaw that prohibits the use of smoking, or can this be all-encompassing?
I think there still needs to be a level of reasonable regulation that comes into this, Duncan. Most certainly, these amendments to the legislation will a mirror the RT decision. That's essentially what they're doing. And they're allowing the body corporate the ability to have these types of blanket prohibitions built into bylaws which look to regulate. But in my view, it's pretty clear that if a body corporate wishes to do so, they can enact a bylaw which covers a lot of, if not all of, the outdoor areas in terms of smoking. Practically, where does that then sit smokers? Smoking within the boundaries of their lot, really? Well, internal boundaries of the lot, or smoking off scheme land. So I think it will have a pretty big impact in terms of smokers and where that ultimately progresses to as well.
Yeah, and I think this ties in quite nicely with our earlier discussion on nuisance, that while the body corporate may have these bylaws in place to prohibit the use of smoking products in outdoor areas, if somebody's smoking inside their living room but with the windows open, smoke wafting across the next door, then that's where we go back to section 167 and the nuisance kicks in.
Yeah, and look, I've had a really good question that what about shared air conditioning vents and the like? You know, if smokers are forced to smoke within the internals of the lot, is there the potential in certain structured schemes for that smoke to then, you know, traverse different lots through ventilation systems and the like? Yeah, I don't know, but it's got potential, and you're right. Yeah. That's where, yeah, even if you have quite a descriptive bylaw, which is mirroring the slide that we have there, there's still protection in that statutory provision of 167 that allows a bit more of a broader, greater scope when it comes to nuisances and hazards.
Very good. Okay, pets. Now, this is reasonably straightforward. The takeaway in regards to the bylaw amendments for pets is that it's now prohibited for a body corporate to have a bylaw prohibiting the keeping or bringing of any animal onto a lot of common property, or restricting the number, type, or size of an animal that an occupier of a lot may keep or bring onto the lot or common property for the scheme. So really the restrictions on those components fall to the local government ordinances and requirements, so that if there's a prohibition on, say, keeping chickens in a residential area under the local government bylaws, then those restrictions apply to the body corporate. But if it's permissible for somebody to keep 2 dogs within a lot under the local government bylaws, then the body corporate can't place tighter restrictions than those that are already in place.
Couldn't agree more, Duncan. Here, it's really important for committees, owners to know that there is still reasonable conditions that a body corporate can impose in pet approval when it comes through the scheme. This isn't a blanket approval for any and all pets to come onto the scheme without prior notification or approval from the committee. Same process still applies. All this amendment is looking at doing is trying to rule out those bylaws that I still see, and on quite a frequent basis, where it says you're only allowed 1 small dog that's no more than 10 kilograms, or you can only have certain breeds that the committee feels are more susceptible to apartment style living. So it tries to eliminate those high dispute yet very consistently held outcomes for pet disputes, but very much still relying on council rules and regulations. So there are certain council rules and regs when it comes to the number of pets that you can keep within a lot, and they are somewhat different between the different council zones as the like, but it is really important to just make sure that any bylaw you have is still consistent with local rules and regulations.
Yeah, and you made a really good point earlier that it doesn't prohibit a body corporate from having rules and regulations about how pets can be kept within the common property areas. So the body corporate can still restrict pets from swimming pool areas or barbecue areas, or must be kept in a lead at all times while on common property. Those items are still permissible.
Couldn't agree more. And there is still scope to be able to seek for a pet to be removed from a scheme, as well if there's a contravention of those reasonable conditions and the approval which is ultimately given. So the only other interesting part is the risk to native fauna here that you've got as an exemption too. So this, in my mind, really comes down to the drafters turning their minds to eco lodges or certain type of schemes that have certain council overlays or protections or the like. So there are still those grey areas that you can apply for certain schemes too.
Very good. Fantastic. Okay. Towing. Let me go back to towing. This is a good one. Okay. So this is the introduction of Section 163A, towing motor vehicles from common property. Again, Jess and I had a really constructive discussion on this one about what the amendment actually contains and then what's best practice. So all the amendment contains is really saying that the Act, the Body Corporate and Community Management Act, does not prevent a body corporate for a community title scheme from towing a motor vehicle from the common property for a scheme under another act or otherwise according to law, and also that a body corporate doesn't need to go through the normal bylaw contravention process to have a vehicle towed if it's unlawfully parked on common property for the scheme land. But that doesn't mean that from the commencement of this legislation that body corporate committees can start towing vehicles willy-nilly. There still needs to be a structured best practice process for bodies corporate to adopt to make sure that they're complying with the other acts that are in place for towing vehicles, and also protecting themselves and the lot owners from any potential litigation if they unlawfully tow a vehicle. But really, it's the best practice would be to have adequate signage, an appropriate bylaw in place, and making sure that, I guess, similar to CCTVs, there should be a policy in place that the body corporate adopts for the practice of towing vehicles if that ever arises. So just your thoughts on that?
Yeah, look, like what we spoke about earlier, Duncan, I think the First Amendment really looks to be like an acknowledgement that vehicles can be towed outside of the Body Corporate and Community Management Act, and it is not going to be a governing piece of legislation in which says this is the only recourse that a body corporate has to tow a vehicle. So if, for instance, you and I spoke about a vehicle that causes an obstruction to a fire escape or something like that, there may be another law that allows that vehicle to be towed that sits outside the Body Corporate and Community Management Act. Fantastic. This acknowledges that the body corporate can use that to tow. Trespass is another good example of another law that sits when you're dealing with vehicles and the like. The second one, I agree with your assessment. It's very much a best practice. And, you know, what I turn my mind to here is any and all decisions made by the body corporate and by a committee must be reasonable in how they do that. Now, is it reasonable to tow a vehicle where no signage is erected that you can't park there? Yeah, it's questionable. So in my mind, a lot of these amendments, it is much of the same in terms of the process, but there's going to be an element of best practice that a committee should still turn their minds to before proceeding to tow, to ensure that they're still exercising that reasonability test in that process as well.
Yeah, and a good example of that is that a lot of bodies corporate have, especially ones with holiday accommodation, have a requirement for an in-house requirement for any visitors to register their vehicle with the on-site manager to inform the on-site manager that is a visitor to a lot included in the scheme. But that's not actually a requirement. So somebody may have a common law right to park there as an invitee of an occupier of a lot, but then in turn, if that vehicle is towed away without adequate signage, without adequate notice and without adequate investigation, then it may create a greater problem for the body corp.
Vehicle identification is always going to be the issue in these types of matters, isn't it, Duncan? It's
exactly,
you know, as much as these amendments look at simplifying a process to tow, the issue is still how do you identify who the vehicle belongs to in that process, and then working out what their rights are in terms of parking there as well. So I still think it's positive in terms of the practicalities. It's just still very mindful of making sure that you can identify the vehicle owner and identify what right they are parking on that scheme land with as well.
Very good. Okay. Okay, and layered arrangements. Okay, this is actually a really interesting one too, that that the amendments create a little bit more flexibility and for decisions to be made about bylaws and dispute resolution about bylaws to flow through a layered arrangement, because up until now, the process could be a little bit complicated and convoluted. So one thing that Jess asked when we were preparing for this, which I think was a really relevant question, is it wasn't necessarily about the amendments, it was more about the practical application. One of the amendments that is coming through is that a lot owner in a lot in a subsidiary scheme can lodge an application to resolve a dispute about an owner in a lot in another body corporate, provided those two bodies corporate are under the same layered scheme, and that dispute can be handled through an adjudication process. Just question is this going to minimize the amount of workload and make it a more practical solution? And the short answer is yes, because the process that would have had to have been adopted in the past would be an owner would make a complaint to their committee about the behaviour of a owner in another scheme. That body corporate would need to take that up to the principal scheme, then the principal scheme down to the subsidiary scheme, and then that subsidiary scheme down to that owner. At least now it can just be a direct line between two owners within two different bodies corporate within the same layered arrangement.
Yeah, look, I think these are really practical amendments to layered arrangements. I think they recognise the clumsiness of the existing scheme in the sense of, even for PBC to be able to enforce directly against a subsidiary owner or occupier, to me that used to be a two-tiered process. Now it's a one-tier process, so it's a much simplified version. And it recognises the fact that it's in its name. You're all a part of a layered arrangement. You all have some level of connection to each other. And that should be reflected in the administration processes of that layered arrangement as well. So I think it's going to ease a PBC's workload, especially when it comes to the effectiveness of bylaw enforcement in the layered arrangement. But where I think it could add or burden the PBCs is the amendment to allow subsidiary owners to directly access PBC body corporate records. I think that could probably add an administrative task. What do you think, Duncan?
Yeah, look, it will add an administrative task, but I guess the reality is that would there be any reasonable objection to that owner being an interested person anyway? So I think that there's an argument to say that it's codifying what would have been applied in practice in the past. Yeah,
true. And look, I think as well, it's the practicalities of eliminating the tiers, and a lot of these amendments, in my mind, just look at trying to eliminate the two-step process and just flowing on from a basic scheme. What do you do in a basic scheme? You can do that in a layered arrangement as well.
Yep. Very good. Okay, alternative insurance. Okay, this is a relatively minor change, but material change, especially for the bodies corporate in Northern Queensland. Up until these amendments came through, one of the limitations which seemed just to be an oversight, is that alternative insurance arrangements were not available for lots or bodies corporate that were created under a standard format plan of subdivision. So this is in my mind, the correction of an omission that was in the legislation in the past. And just your thoughts on this as well?
Yeah, look, I think that it could have gone a lot further, but I think this is a step in the right direction in the sense of providing at least a recognition of some other alternatives when it comes to insurance provisions as well.
Yep. Very good. Code of conduct. I'm going to flick this over to you, Jess, because I haven't done my homework on this one.
Go for it. So pretty straightforward amendments actually to the code of conduct, everybody. So Schedule 2, Section 2 has just been broadened to now read a body corporate manager and a caretaking service contractor must not attempt to unfairly influence the outcome of an election for a body corporate committee. And it's also included an additional subsection 3, which reads that a body corporate manager or a caretaking service contractor must not unfairly influence or attempt to unfairly influence the outcome of a motion decided by the body corporate. So that subsection 3 is an entirely new provision in the Code of Conduct. Now, I've already fielded questions from strata managers concerned about, well, what does unfairly influenced mean? Often strata managers are engaged to do circulars to write on behalf of the committee about motions and to canvass the committee's thoughts and processes about certain motions as well. Is that because it appears on a strata manager's letterhead, unfairly influencing? Not in my view. This is where the importance really is about canvassing any correspondence that's being issued on behalf of your committee or body corporate under direction of your committee or body corporate. And it's very much, you're just the mouthpiece, essentially, for the committee moving forward. These types of amendments, in my mind, are where service contractors are taking it on in their own individual right. So this is a company call or an individual call, making these calls, doing these emails, doing the campaigning and the lobbying for that company rather than at direction by the committee. What are your thoughts on that one, Duncan?
Yeah, look, it is one of those amendments that are concerning at surface level, but given everything that we need to take on board as body corporate managers, I'm sure that a lot of the people who are attending this webinar are already acutely aware of managing that line between what we do, what we're instructed to do, what we put on our letterhead, as opposed to what we strongly suggest should come from the committee directly, especially if they're making comments in regards to outcomes of certain motions for a general meeting. So I guess a good practice is to make sure that if anything's been circulated with the notice of a general meeting, that's approved by the committee before it goes out, not just the chairperson saying, I want this circular included with the annual general meeting notice, or the secretary saying the same. And if you are circulating that, taking the time to read what's being circulated if you're not party preparing it, and don't hesitate to speak to your employers or supervisors if you have any concerns about the contents, because there's been a number of body corporate managers drawn into defamation issues because they've published documentation that was potentially defamatory, even though they weren't the author of that document.
Look, I think it's always very important for the capacity in which you're writing in. Most strata managers that I see often canvass that capacity in the first sentence. It's like most lawyers, we act on behalf of blah and write to you in the capacity, or we are instructed, our client instructs So a lot of it does come down to the language that you're using and the capacity in which you're communicating with as well. Mindful of the time, we've got a couple of questions which I'm happy to kickstart on, Duncan, if you're happy for me to do so.
Yeah, fire away.
All right, Gillian's question is, would termination plans also include contracts such as lift arrangements or agreements and bulk electricity agreements? Yes, my view would be that it would fall into a liability, Gillian. So that would come into your plans, that would come across as well. This is very much looking at broadly, what are your assets? What are your liabilities? What would you ultimately need to do? Even if it's like winding up a company. You wind up a company, you need to bring finality to everything that's in that company. So most certainly it would look at that in my view. Colette, if a caretaker / letting agent still has 20 years or so on their agreement, how is that resolved? Is the body corporate required to pay out the term of the contract? That's a really good question. And there is some reference, Duncan, in there.
Yeah, I'm looking for it right now, but my recollection is that it's based on evaluation of the management rights. And the caretaker,
yeah, sorry,
they get first slice of the pie out of whatever is paid on the termination. So whatever that valuation is deducted from anything else that gets distributed to other parties.
Yeah, so there is specific provision in there, Colette, that deals with that. And I'm pretty sure the language is fair market value or something like that. Yep. So their agreements will be valued. And like Duncan said, they have specific protections built into the bill as well.
And that's only for not for other service contract providers, just for caretakers.
Only for caretakers.
That carve out, yeah.
Duncan, this one's from you, from Frank, just questioning the 1 vote per lot in the bill. Yep. Do you know specifically where you read that one from?
Oh, yeah, it is somewhere in the back. I'll find that in
we'll
just a
second. Have a look at that while I answer Cindy's. Cindy's question is, if a set of bylaws doesn't include a smoking bylaw, is the committee able to address smoking complaints directly referring to the legislation, or would they have to refer complainants to the BCCM office regarding the complaint? Great question. So Cindy, if you don't have a specific smoking bylaw, any owner or occupier can rely on the new statutory provisions when they come into effect. So the amendments to section 167 sit outside of the bylaws. So irrespective of you having a bylaw that regulates smoking, 167 will be available to any and all owners and occupiers within the scheme. It's just if a body corporate wants to put into place a new bylaw that you can have essentially 2 avenues to explore rather than just one.
And just going back to Frank's question, it's section 81K subsection 5. This is where it comes to the terminology about a general meeting to consider a termination resolution. 1 vote only may be exercised for each lot included in the scheme.
Perfect. Thanks, Duncan.
No worries.
Sandy, re code of conduct. What if a caretaker is also an owner of a lot in the scheme? Owners are allowed to lobby other owners via direct contact. Yeah, look, correct. Sandy, there's going to be an element of give and take in here. My view is that it's not... There's going to be a line that's going to have to be drawn, probably in case law, that's going to differentiate lobbying and somebody having the ability to voice their opinion compared to unfairly influencing. And that, in my mind, is only going to come down to decisions that are going to be made in case law and the like about how that new code of conduct application can be presented. And it's also still going to come down to the capacity in which people are writing and campaigning on as well. But I do take your point, that could become problematic when they have 2 hats to wear. what hat are they using when they're communicating with other owners as well. And also it's fair and reasonable for committees, for interested parties to lobby and campaign. It's just how they're going about that.
I'll just quickly touch on that too. I think Karsten
Sure.
might have wanted to have a comment perhaps on that as well. But I always look at the higher restriction applying. So an example that I would give is that if I owned a lot included in the scheme and our body corporate management company was also the body corporate manager, while on the one hand I could have the ability to be a voting member of a committee because we're a body corporate service provider, I couldn't be a voting member of the committee. So I'd always look at the code of conduct on a caretaker to prevail over their rights as an owner, because I'm a conservative person. Yeah.
That best practice component.
That's it, yeah. Yeah.
All right, I think that covers the questions for now. We're probably going to keep working through this flow chart, everybody, and then probably put it for board endorsement to then be circulated out once we have a settled version. But I'm sure you can all appreciate we've had a pretty quick turnaround, and we wanted to show you what we've been working on to show you also what to expect is going to come out soon. So watch this space. We'll come back to you about commencement date once that comes about. Once we have a settled flow chart as well, we'll distribute that with hope that eases the practicalities of how we see this process too.
Yeah, I'll just add to that as well, just for those who are in attendance still, is that there's an additional benefit to having that flow chart, and I would strongly encourage that when you receive that to make sure you save a copy of it, because if the question of scheme termination is asked at a general meeting or committee meeting, that would be a good tool to show to the committee members that yes, this is a complicated process. It will take some time to get through this process, and there will be some costs associated with it. So while we're considering this, we also strongly encourage the parties to communicate with each other and try and work out a mediated, negotiated resolution, because I strongly believe that is going to be the way that these issues are going to be resolved, rather than going through this lengthy process.
Couldn't agree more.
Perfect. All right, that should be all for tonight. Jessica and Duncan, thank you very much for offering up your time this evening to talk to us about the changes. If anybody's got any further questions or feedback, feel free to reach out, and also keep an eye out for more information on the commencement of all the new legislation. Thanks everyone again.
Very good. Right,
Thanks everybody.
Right,
Thanks, Duncan.
Bye-bye.